Well, hello everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. I'm glad you're here with me tonight as we deal with unexpected technical issues. Not that that's ever been a problem before. We'll blame it on solar beams. That's it. Yeah, that's it. The solar radiation came through and it changed a bit on my computer. That can happen, by the way. That's actually a thing. Yeah, the solar radiation came into my computer chip and it flipped a bit and it caused the stream to stop. That's what we're going with. Solar radiation. We're back. We're back. And as you can see, I am remote. I am visiting my parents for a little early Thanksgiving visit. I thought I'd come a little early and spend some time with them. And so I'm visiting my parents and we're having a good time. And I am glad you're with me. So, yeah, and I'll give everyone a chance to find me. So we'll just faff around for a second while we give everyone who is waiting for the previous thing to start a chance to find for the new thing to start, because that's how well it's going for me. For me. But it's okay. We could have bigger problems, right? So we won't let it get that. We won't let it get to us. Yeah, we'll give a second for everyone to get back here. So yeah, I'm having a nice little visit here in South Carolina, in the upstate, near the mountains. Nice little part of the region, nice little part of the state. Don't mind it at all. You know, got up in the mountains, get some, well, you know, Appalachian at least, right? Appalachian mountains. You know, those West Coasters will say it's not a real mountain, but that's okay. Get up in the mountains, get some nice air, watch the leaves. It's quite a bit chilly. Things are going well, ma'am. It's going super well. Yeah, Laura, it was definitely confusing. I don't know what happened. I don't really know what happened. It's just technical issues. It happens. I don't know why, but it happens. But that's okay. At least my camera's working and my mic is working properly. I got the right microphone working. So, hey, it's not that bad. All right. Let us discuss the breaking news tonight. Mr. Sam Bankman-Fried. Things did not end well for Mr. Sam Bankman-Fried, which only literally everyone would know if they were paying any attention whatsoever. Sam Bankman-Fried was running a Ponzi scheme a la Bernie Madoff. And a la Bernie Madoff, it doesn't work when new money stops coming in, right? Because you use the old money, you use the new money to pay the old money, right? And it stops working when you run out of customers because it was never really real, right? And basically running a gigantic Ponzi scheme. So, and much like Bernie Madoff, who got jail for life, Mr. Sam Bankman-Fried is facing up to 110 years in prison. Now, I don't think he'll get all that. That's a statutory max. So he probably won't get all the 110 years. But I think it's safe to say that Mr. Bankman-Fried's immediate future is not looking so great. Not having those same luscious homes in the Bahamas and California that he's used to for the foreseeable future. So maybe if he's really lucky, he'll get to breathe free air when he's old. So that's what he has that is what he has to look forward to. If he's really lucky, maybe he'll only get like 40 years in prison, and maybe he'll be out of jail just in time to take Social Security if he's really, really lucky. So, not ending well for Mr. Sam Bankman-Fried. The jury taking about 5 hours to do this. They weren't going to be in tomorrow because one of the jurors had a conflict and they had already resolved that issue, right? So the judge had already said, look, you guys don't have to come in tomorrow because one of the jurors had some sort of family birthday party or whatever. But, you know, they they told the judge about it. The judge was like, okay. So the judge knew about this thing, some big family reunion or whatever. And the judge's like, fine. So, you guys don't have to come in Friday because juror number 10 over here, has to go to the family birthday bash or whatever, And so basically it just became the weekend, right? It's like, do you want to come back in on Monday? Right? So today just basically became Friday, right? Do you guys want to go away for 3 days and come back? So like many things, like the jury wants to go home and they don't want to come back after the weekend. Also, he's super duper guilty. He's incredibly guilty. So incredibly guilty. So there's all that too, right? So you combine that with the fact that the jury doesn't want to come back in after a 3-day weekend, after hearing this sordid tale for as long as they've been hearing it. And well, the result is exactly kind of what you would expect. Guilty across the board. So fun and exciting, not going well for Mr. Bankman-Fried over here. The jury has found him guilty on all charges, and this is in federal fraud and conspiracy child, deliberating for a little over 4 hours, somewhere between 4 and 5 before reaching a verdict. The judge saying we'll have decorum in the courtroom when the verdict is announced. Dude, if they're coming back that fast, normally that's actually a pretty decent sign, because normally it's like, it must be not guilty because they come back so fast. But if it's just so overwhelmingly guilty, then it's not a marginal case. So one way or another, like everyone should know what's happening, right? And I think everyone knew which way this was going. Sam Bankman-Fried over here, who's currently 31 and looking more like 71 by the time he's done with this thing, probably, sat motionless at the defense table in an ill-fitting gray suit, which was apparently found on the rack. I think I remember reading this detail. I want to say Macy's, but I might have the department chain wrong. But yeah, it wasn't the suits or like the nice clothing that he was used to. Apparently, they had to find a suit in a rush, and they got him something off the rack at like a Macy's or something. So, which isn't a bad suit. Don't get me wrong. But it isn't exactly the kind of style that he was used to, right? Not exactly what he had hoped for. Bankman-Fried had been charged with and now convicted of 7 counts of fraud, conspiracy, and money laundering. Yep. He was accused of using customer deposits to cover losses at the hedge fund, pay off loans, and, enrich himself. He had pled guilty to not all the counts. He could face a sentence up to 110 years, but again, that's a statutory max. He won't get that. Maybe it'll be 20 years. Maybe it'll be 30 years. Maybe it'll be 40 years. But you know that the prosecution's going to ask for a lot. They're going to ask for an upward departure. So I wouldn't exactly have a lot of hope. He won't be having a lot of internet in his immediate future. So all that talk about, all that talk about stuff, him having, laptop access and all the rest of it. Yeah, and I'm sure his lawyers will spend some fun time having appeal, but, I wouldn't get their hopes up. With any sort of appeal options. Judge seems like he runs a pretty tight ship. Bankman-Fried, of course, let's call it, stepped down from his role in FTX when it declared bankruptcy, which might have, in the end, been what really doomed him. Because when you file bankruptcy, you have to file the books. Because we have to figure out what the assets are, right? And the liabilities, right? So that's probably what ultimately doomed him in the end. Not that he had a lot of great options, incidentally, but because he filed bankruptcy, he had to turn over all the books. And once you turn over all the books, 1 and 1 don't add up to 3. So it doesn't really work. So the bankruptcy, as Rob has pointed out, will often expose many sins. because they're going to go through the books and they're going to audit the hell out of you to figure out what the assets are. And if things don't add up, and they don't add up in a major way like this, you're going to have a bad time. During the month-long trial, the prosecution laid out the case that this was an elaborate and intentional fraud, while defense tried to blame him just being, a naive math geek. Of course, Sam Bankman-Fried himself took the stand in his own defense, which the prosecution then, of course, as one would expect, turned right around and used his own statements against him in their closing arguments, because of course they did. Sam Bankman-Fried said, all the time, I don't remember things. The prosecution, that's okay, we remember. Roll that beautiful bean footage. So, yeah. Sam Bankman-Fried testified that he only learned 2 months before FTX collapsed that Alameda had spent $8 billion of FTX customer funds. That seems like the kind of thing that if you're the head of a large crypto exchange, or really any kind of exchange, $8 billion is a fair amount of money. You would think $8 billion being missing would be the kind of thing that might possibly show up and be something that would command one's attention, right? Or is it that old saying, a billion here, a billion here, there, and suddenly you're talking about real money? Because that's what Sam Bankman-Fried is looking at this thing, right? So yeah, it's going all that well. Over here, picture Sam Bankman-Fried looking like an absolute schlub, which he is. No more tequila shooters for you, sir. Your only tequila now is prison wine. Not recommended. Carolyn Ellison, the former chief executive of Alameda, had previously pled guilty to criminal charges and is testified under cooperation agreement. Carolyn Ellison testified that Bankman-Fried believed in utilitarianism, which apparently included eugenics, based on previous statements we've seen from him. Not that that's concerning in any way. And thought rules against lying or stealing inhibited his ability to maximize his greatest benefits. So he was stealing for really good reasons. He's Robin Hood, don't you know? But he's Robin Hood with many palatial states. I seem to vaguely recall that in the story of Robin Hood and his merry men hung out in Sherwood Forest, not in a multi-million-dollar palatial estate, times several, in multiple locations. I don't remember that version of Robin Hood, so yeah. FTX co-founder Gary Wang also admitted to committing fraud, securities fraud, and commodities fraud with other people, including Bankman-Fried. Wang also, of course, testified under an agreement that will see him spared the worst consequences of all this stuff. So it did not end well for Sam Bankman-Fried, and his lawyers will undoubtedly appeal, and he'll undoubtedly lose. I have a lot of confidence. This judge seems like someone who is pretty sharp on the ball and made orders because it's like, yeah, this train is moving. Choo-choo, people, right? This train is moving. And so we're doing this thing in this way, and we're not getting bogged down in stuff, which I appreciate. I appreciate that. I appreciate a judge who doesn't let things get stuck, in some sort of discovery hell or motion practice hell or whatever. It's like, choo-choo, people, let's go. And I appreciate that very much. So, yeah. I can't speak to the parents and whether they'll plead or not, or what liabilities they even have, to be honest. I'm not sure what liabilities they have. But we did, of course, hear from Bankman-Fried that his father, at least, had some interesting involved. Are there tartan swatches on the wall behind you? They are tartan swatches on the wall behind me because my mother's side is Scottish. And so she has that up there to represent her Scottish side and my Scottish side of the family. So yeah, I did the Ancestry.com one time. I did a full family tree, and my mother's side, yeah, we were tracing it back in Scotland. Yeah. From what clan? I want to say McGregor, but I'd have to double check. So yeah. But yeah. So my mom's side is all Scottish, all Scotland through and through. Both my mother's parents. And like, so my mom's side is just about as pure Scottish as it can be, right? Because I did their family tree, and it's just all Scottish or direct Scottish descendants. So my mother marrying a non-Scot was the one who polluted that bloodline, I guess, because like basically as far as I could tell, like every one of my mother's ancestors was either Scottish or had married Scots and direct descendants of Scots. So it's about as pure Scottish as you can be on my mom's side. So, yeah. So that's pretty interesting. And then my father's side is German. I have never worn a kilt. No. So Scottish and German, for those of you who are interested in my ancestry. When I did the DNA test, it was 100% Northern European. 100%, which I thought was hilarious. I just thought that was hilarious, right? It's like you do a DNA test, and where are you from? Northern Europe, all of it. So yeah, it's funny because I am the whitest person ever, right? No Native American, no African, no Asian, not even Southern Europe. It's all Northern Europe. It's all England, Scotland, Germany, a little bit of the Norse countries, northern France, and that's, yeah. So yeah, my ancestors just were like in this little part of, the thing. So that's a pretty interesting thing. So I was like, yeah. Whitest guy right? Yeah. So yeah. So I always thought that was funny. I always thought that was funny that I'm like super duper white. Incredibly white. So yeah. On a different topic, other than my incredible white heritage, yeah. I deleted all my DNA results after I got them back because I didn't want to keep them in the cloud. So I can't just log in to check again because I deleted all the results so that they weren't deleted all the data. But I thought it was interesting anyway. Anyways, what was I going to say? Oh yes, in my YouTube journey, I'm happy to say that the edited videos seem to be doing very well, at least comparatively. The last one that we did, did about 3x the normal video rates. So that was really, really good. When we did the video on Take Care of Maya, did about 3x the normal performance. And so that was good. And the other edited videos we did either did like 2x or plus 80% or something like that. So that was really good. So I'm going to keep sticking with that format. Obviously, I'm on the road right now, so I can't produce new content right now. But when I get back, I plan on doing more edited content and going from there. And we'll see how that goes. And also, I purchased a new microphone for when I get home. So I'm interested to see how this turns out. I think it's called the Mackie EM99B. Dynamic microphone. I've been hunting for a new microphone, and they had one as an open box on Amazon. The Mackie EM99B. So I got a new microphone. So I've been using the Rode NT1A, for as long as I've been recording stuff, condenser microphone, and I thought I'd give a dynamic mic a shot and see what that does. And I've been listening to reviews, and this Mackie one sounded really good, and they had an open box one that was like half off. So I picked it up because I figured, I'd give it a shot. So it's like $150 microphone, and I got it for like $80 on Amazon. So I'm pretty stoked about that. Yeah, voice is good here. Yeah, right now I'm using the Rode Smart Lav Plus lavalier, which is a fine lavalier mic. So, so we get decent audio on the road, so I always try to bring you good quality stuff, right? So I'm not going to bring my whole microphone setup, with a really nice super duper microphone, but the little Smart Lav Plus is not a bad mic for the road. It's like a $70 microphone too. So it doesn't work too bad, does it? Yeah. All right, let's cover some new stuff. Now that we've been talking about behind the scenes stuff for a while. So we're going to spend a little time on this because I think it's interesting. Alex Murdaugh's motion for a new trial and also his motion to recuse has been filed. Alex Murdaugh, as you will recall, was convicted of murdering his wife and son at Moselle in South Carolina with a shotgun and a rifle, I believe. Yeah, because 2 different weapons were used. And I at least thought the evidence was a little spotty, to be honest. But the more to the point for our purposes is, more to the point for our purposes is when there was some jury tampering or possible jury tampering from the clerk of court. So we'll read a little bit of this motion that they filed, and they also filed a motion to recuse, which I guess we could start with this. Now, this is a motion to recuse the judge, which was filed interestingly in the state Supreme Court, which is an interesting. I'm not sure why that is why this is in the Supreme Court, as opposed to being filed before the judge in a motion to recuse, which is what you normally do. But this is being filed as a writ for prohibition in the original jurisdiction of the state Supreme Court, which seems like a very odd thing to do, to be honest. Now, I think that Judge Newman should step aside, to be honest. So I think that asking him to recuse is perfectly proper, but I'm not sure why they're doing it this way, and I'm not sure what is going on there. I'm glad to know the mic caught the snort very well. That's good news. Okay. So the basis for the petition is that Judge Newman has personal knowledge about the clerk's conduct, which might very well be true. Further, after the jury verdicts, Judge Newman made numerous statements in violation of the code that required disqualification from further proceedings. This apparently included congratulating the jury for returning a correct verdict, statements at sentencing eviscerating personal bias, statements in public interviews after the trial, in which he stated his personal opinions regarding the guilt, legal issues on appeal, and strategic choices, which I'm not sure that's necessarily improper either once the proceedings is over. We can skip the background of the case because we all know the background of the case. We watched it together, so we can skip that. Except we go to here. All right. So we'll pick it up here when the trial is over. When sentencing Mr. Murdaugh, Judge Newman repeatedly expressed disdain for Murdaugh's denial of murdering his own family. Murdaugh filed a notice of appeal on March the 9th. 19 days later, Judge Newman gave a lengthy public interview about the trial at his alma mater, the Cleveland State University College of Law. In the interview, he openly expressed opinions about defense counsel's decision to seek a jury view of the murder scene. He expressed personal opinions regarding guilt. He also explained his reasonings for decisions to allow weeks of testimony on the admitted financial crimes unrelated to the murders, which I think is a valid basis to appeal as well, incidentally, that those cases came in. On August the 1st, the Colton County Clerk of Court, Rebecca Hill, published her book, Behind the Doors of Justice, which we have spent some time reading on stream. And boy, oh boy, hasn't it just been a page turner. It's been glorious and wonderful and just really Nobel Prize material for literature. I mean, am I right? Of course I'm right. The book was the final straw that led to some jurors coming forward to describe the jury tampering. In the brief, jurors stated that after the state and defense began to rest their case, or after they rested the case rather, Miss Hill entered the jury room often, telling the jurors not to let the defense throw you off, or not to distract or mislead you, and telling them not to be fooled by the testimony. She apparently had multiple private conversations with the jury foreperson. She apparently fabricated a Facebook post in an attempt to remove a juror she thought might vote not guilty, which I don't know if that was fabricated or not, but they say they are. Yeah. And then she interrogated the jury, or the post was fabricated, not that she did it, though. Or at least it wasn't what it purported to be. I don't know if it was strictly speaking fabricated. It appeared to be from someone that wasn't that person, but whether it's fabricated or not, who knows? Well, after Newman made the comment, Miss Hill interrogated the jurors again about her views of the evidence presented and the views of the juror. When the jury began deliberations, Miss Hill told them it shouldn't take us long. If they deliberated past 11, they'd be taken directly to a hotel, even though none of them were prepared to stay overnight. She told the jurors they would not be allowed to take smoke breaks, as they previously been allowed to do during the 6 weeks of the trial. There were 6 smokers on the jury. She told the jurors that after trial they'd be famous and predicted the media would request interviews of them. She even handed out reporter business cards to jurors during the trial and traveled with jurors to New York City when they appeared on the Today Show. It's going just that well, people. It's going just that well. On September the 5th, Murdaugh filed a motion to suspend his appeal and for leave to file a new motion for new trial based on the evidence. So, yeah. So, the Supreme Court can issue writs of prohibition in its original jurisdiction. A party can seek an extraordinary writ by petition. I'm sure you can. Seems like an odd way to go about it, but okay. Why wasn't this reported earlier? It has been reported earlier. We've discussed it earlier several times. So we've definitely been talking about it for a while. So yeah, this has definitely been reported earlier than just now. So they talk about the legal standards for the thing. They talk about he has the requirement to recuse himself because he has personal knowledge. Yes, he does. So that is a basis to recuse. Comments after the jury verdict were returned violate Can 3. Yeah, he apparently told the jury, a judge shall not commend or criticize jurors for their verdict other than in a court order or an opinion in proceeding, but may express appreciation of jurors for their service for judicial system and community. But he apparently told the jurors, I'll make no comment now as to the extent of the overwhelming nature of evidence, but certainly the verdict you've reached is supported by the evidence. Well, I mean, he would have to believe that or he'd be reversing it. Circumstantial evidence, direct evidence, all the evidence pointing to only one conclusion, and that's the conclusion you've reached. That goes too far. So I applaud you as a group and unit and individually evaluating the evidence to come to a proper conclusion. Yeah, that's too far. To say it's supported by law is one thing. To say it's correct is another thing. And it may sound like a small distinction, but it's not. They cite a New Jersey case. They cite some other evidence. Personal bias. I don't know about that. But he made some other comments that maybe reflect potential bias, but you can't have bias that comes from outside the case, right? But as the evidence builds and you're weighing the evidence, right? Judgment is not the same thing as bias, in other words, which is what I've told you before. Judgment is not the same thing as bias. So if you reach the conclusion that something is true, that doesn't mean that you're biased. And so I think they're conflating judgment with bias, at least in part, right? Because as the trial goes on, the judge and the jury are going to form conclusions, but those conclusions are not necessarily biased, even if they strongly favor one side or the other. That's not the same thing as bias. So I don't think this argument quite works. The extrajudicial statements. A judge shall not, while proceeding is pending or impending and in court, make any public statements that might be expected to affect the outcome or fairness of the fairness. And the requirement judge abstains from public comment regarding a pending or impeding proceeding continues during any appellate process and until final disposition. Okay, fair enough. That makes sense to me. As if that's the rule, that's the rule. So because the appeals weren't finished, he shouldn't have commented on it. He's required to disqualify himself from hearing the motion for new trial, but you didn't ask him. You're asking the Supreme Court. Mr. Murdaugh has a right to hear the cause heard by a judge who's not required to disqualify himself. Sure. I don't know why. He has no effective legal remedy to vindicate his right other than an extraordinary remedy writ from this court. If a judge, why can't you challenge him on the motion to recuse? I guess. Why does it have to be filed here? The usual remedy for an error by a trial judge is an appeal. Where bias is alleged, the applicant must show the alleged bias is personal as distinguished from judicial, right? Because again, judgment is not bias. So if you reach a conclusion within your judicial world, that's not bias, that's just judgment. That stems from extrajudicial sources. Again, because if you heard it in court, it's not bias. All right? And that results from a decision on the merits based on considerations other than what the judge learned about from his participation in the case. So if it comes from what you learned about in the case, you're entitled to come to a strong conclusion if the evidence supports them. Here an appeal does not protect Mr. Murdaugh's right to have a motion for new trial heard by an impartial judge. Mr. Murdaugh's motion for a new trial will not be decided on legal argument. Everyone presumably will agree that Hill's alleged conduct, if proven, is cause for mistrial. The dispute is what in fact happened. The presiding judge will decide that as a fact finder. There are witnesses supporting Mr. Murdaugh's position, at least one witness who contradicts them. These factual findings will be based on relative credibility of the witnesses, and those findings are effectively unreviewable, which that's true. Although that's not, of course, not a unique problem here. That's just true in every case. You don't review facts on appeal. Trying to overturn a case on appeal based on the facts, yeah, that doesn't, no. You don't do that. If you can do that, you've climbed a mountain on a very windy day in your shorts. It's a tough haul. Even if standard review did not forbid appellate review of credibility determinations, it's possible to show the credibility determination stems from extrajudicial sources. Yeah, the judge is just too close to it. The judge is just too close to it. And that isn't necessarily a knock on the judge. The judge might be a very good judge. I'm not making aspersions on the judge generally. The judge just happens to be too close to this particular case. There's at least some things that he saw and heard and experienced, and he's likely a necessary witness, which necessarily precludes him from being the judge. You can't be both a judge and a witness in the same case, right? So he's just too close to it. And I take no particular position at this time what the ultimate right ruling here is in terms of a new trial, because we have enough information to raise the question, but we haven't heard testimony in court, and we haven't had the evidence presented in a formal proceeding. So I think it's a little premature for us on the outside to say that there should be a new trial for these reasons. If we were on appeal, right, I'd be saying I think we should have a new trial because the financial evidence was so excessive as to violate 403, because it was substantially more prejudicial than probative by its voluminous nature. So I would on appeal be strongly inclined to set aside the verdict for that reason. But whether I would set aside the verdict for this reason, I don't know. We haven't, because the 403 question on appeal is a legal question based on facts we've heard in court. That's why I'm able to reach the conclusion, right? We've heard the testimony in court. You and I were there. We watched it. So all the evidence I need to be able to reach the legal conclusion I already have. Because the 403 question about whether the evidence is excessive, it's based on the evidence which we've heard, right? So I'm able to reach a legal conclusion here. I don't know enough, and I don't think the record is clear enough from the extraneous sources. I don't think it's clear enough from this to reach the final disposition. So I don't know what should happen, but as to this, but I definitely believe there should be a hearing, and I believe that the judge is probably a necessary witness, and even if he's not, I think he's too close to it to make a decision. Which, yeah. Gui Seppi says, is the judge not responsible for the behavior of the clerk? No, not really. Not in this situation, no, because the clerk in this jurisdiction is independently elected. So they are not a pure, in most judicial systems, you'd be right, because in most judicial systems, the clerk is appointed by the judge. But not here. They're elected for some reason. I don't know. So I'm not sure that the judge is responsible for their clerk in this situation, because they're independently elected. So so it's a weird situation. Yeah. If the fact finder is a judge who denounced Mr. Murdaugh on national television, the decision for a motion for new trial be unreviewable and forever suspect. Mr. Murdaugh's rights to an impartial judge can only be preserved by prevention, not remediation. I think this judge should not hear this case. He's just too close. He's just too close to him. So they're asking the Supreme Court for a judgment that he's violated the rules of judicial conduct. That's a bold move, man. If it doesn't work, you've already pissed off the judge even more. Yeah. So they want to rid of prohibition. That seems extreme, but they're going for the gold. They're going for gold. So then we have a trial court transcript, which we reviewed that before, in its glorious detail. Why are there redactions in the record? Oh, these are from chamber. That's why. Wait, no, okay. These weren't heard in open court. Then they give the sentence to the court. Then there's a transcript of the interview with the judge. That's hilarious. Put that on the record. They have a court reporter actually type that all up. That's pretty funny. Pretty interesting way to go about it. Get a court reporter to write up the transcript of a TV interview, right? But there's got to be a better way, but all right. All right, so that's all there is there. There's also this motion for a retrial. We've already covered this in large part, so we don't need to go through this again. But I think the motion should be heard. Whether it should be granted, I don't know. So, we have a statement from this juror. I was juror 630 in the case. So we have a juror saying these things happen, right? That's enough to get a hearing. I was juror 630 in the case. Towards the end of the trial, after a President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury not to be fooled by the evidence presented by Mr. Murdaugh's attorneys, which I understood to mean Mr. Murdaugh would lie when testifying. She also instructed the jury to watch him closely immediately before he testified, including looking at his actions and looking at his movements, which I understood to mean that he was guilty. Immediately after he testified, the foreperson said Mr. Murdaugh was crying on cue. The foreperson criticized the former foreperson for handling Murdaugh a box of tissues when crying on the stand. She told the jury we cannot interact with Mr. Murdaugh because that's what the defense wants us to do. The jury frequently discussed the case during breaks before deliberations. During the end of the trial, Miss Hill came in the jury room a lot. Ms. Hill and the foreperson, juror 826, had a private conversation on multiple occasions. The foreperson would tell the bailiff she needed to speak with Ms. Hill. Ms. Hill would arrive, and then she and the foreperson would go into another room for a private conversation. The conversations typically lasted 5 to 10 minutes. The foreperson never said anything about the content of the conversation. For example, she never communicated logistical information, which normally would be what the clerk of court would be talking about. Like, hey, you guys want to eat food? What kind of food do you want? We're going to take you to a hotel. Here's the hotel we're going to take you to, or whatever, right? So, the fact that the foreperson is not relaying this information is concerning, because there's nothing to relay, right? So she's not there to talk about logistics things. She's there to talk about something else, which, you shouldn't be doing. When we began deliberating, Miss Hill told us this shouldn't take long. And if we deliberate past 11 p.m., we take him directly to a hotel. I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by other jurors. After the verdict and immediately before sentencing, Miss Hill pressured the jury to speak as a group to reporters from a television show. Good Morning America, presumably, is what that says. So that's enough to get my attention. That's enough to get my attention. And then we have an affidavit from another juror, or Holly Miller. Holly Miller. So Holly Miller is there, and she's like, okay, I met with the juror 741. At the meeting, the juror indicated they signed an affidavit, but were unable to arrange a time and place. During the meeting, the juror relayed the following information to us. So this is hearsay, but it's okay, right? Hearsay deals with in court or during testimony in trial. Hearsay, the rules are looser in other forms of practice. So this is hearsay, but it's okay, right? It's enough to get us started. Are you overhearing speech? I don't know what that means. I hope not. Anyway, so this person is testifying what they heard from juror 741. So juror 741, at least according to this person, said, during the trial, she witnessed the clerk of court, Becky Hill, come to the jury room, and Miss Hill and the foreperson went into the bathroom. After Miss Hill and the foreperson entered the bathroom, Miss Hill told the jurors they couldn't ask the foreperson questions. Several times during the trial, Miss Hill told the jurors that the media wanted to interview jurors during the end of the trial, and during one of these conversations, she passed out business cards to members from the media to the jury. During the trial, she's doing this. At the end of the trial, Miss Hill told someone that no one from the media wanted to interview her, whoever that is. Right before the defense put on their case, Miss Hill told the jurors, you're all going to hear things that will throw you off. Don't let them distract us or mislead you. This is hearsay, but again, it's not inappropriate in this context. After Alex testified, 8 jurors indicated they did not believe his testimony. A juror recalled that another juror was very emotional during the trial. During the visit to Moselle, apparently this juror and someone else walked to the scene together. The juror then began walking with the clerk of court. There are times when the jury is not kept together, but are kept in 2 separate rooms. Someone knows the juror is talking about the case before deliberations began. Neither she nor someone else, juror 785, joined in conversations about Alex. As the jury was deliberating, she believed Judge Newman came into the room she was in and told her the jury would have spent the night in a hotel if they didn't vote by a certain time. So, again, and then she notes Ms. Hill's conduct was corroborated by other jurors during subsequent interviews. So it's hearsay, but it's enough to certainly get my attention for a hearing. It's enough to get my attention for a hearing. And so I don't know whether the Supreme Court of South Carolina should grant this, but I think the judge should absolutely recuse himself. And then we got pictures of her book, Behind the Doors of Justice, the Murdaugh murders. You know, she definitely thinks she's the main character of this story, I'll tell you what. So, yeah. She thinks that she is the main character. So, yeah. So that is what's going on in the Murdaugh trial. So they petitioned the South Carolina Supreme Court in their original jurisdiction for a writ of prohibition, which seems a bit extreme, but that's what they're doing. All right, so apparently Lizzie Borden doesn't want to be associated with a coffee shop news. The things we choose to care about, the things we choose to care about. The Miss Lizzie's coffee shop is able to keep their name and logo despite apparently the wishes of Lizzie Borden. How exciting. Miss Lizzie's Coffee, the most haunted coffee shop in the world, with a bloody axe and a coffee cup for their logo. They are here for it. They are here for it. Thought she died? She died a long time ago. A very, very long time ago. Yeah. Miss Lizzie's Coffee Shop, the coffee shop that opened up next to the infamous Lizzie Borden house in Fall River, can keep its name and hatchet logo. They opened the coffee shop next to Lizzie Borden's house. That's cute. The coffee shop opened August the 4th of 2023, the 131st anniversary of the murders of the Bordens, and used the name Lizzie and a drawing of the bloody hatchet on a signage that led to Lizzie Borden's house owner, Lance Zeal, and his company, U.S. Ghost Adventures, signing a cease and desist and then filing a lawsuit claiming trademark infringement. You can't use the Lizzie Borden name for your coffee shop. We have that trademarked. That's funny. U.S. Ghost Adventures owns multiple federal trademarks in relation to Lizzie Borden house business. The company apparently claimed a trademark for the name Lizzie Borden for use of hospitality services and another trademark for a hatchet logo, which it said were being violated by the coffee shop and was a willful and intentional attempt to trade on the goodwill and commercial success that U.S. Ghost Adventures have built up in their marks, and the corollary registration is an attempt to free ride on the success as a preeminent and well-known hospitality provider in the Fall River area. U.S. Ghost Adventures really wants that trademark on the Lizzie Borden things. They're all about it. That's kind of funny. The complaint says that actual confusion had occurred in the marketplace. U.S. Ghost Adventures, for its part, sought to have Miss Lizzie Borden's Coffee change its name and surrender all profits made since its opening, in addition to other penalties. The U.S. District Judge heard arguments regarding an injunction on October 23rd in a non-evidentiary hearing, as neither U.S. Ghost Adventures nor Lizzie Borden Coffee offered live testimony. $10 from the Orange Cow, who says, not sure if you covered it, but a case is an interesting free speech case that's likely going up for en banc review. Thank you for the notes. I will note it. Am I going to the Clemson, North Dakota or Notre Dame game? I am planned on it, but maybe. Please tell me there's not a problem with the video. Nope, still looks like it's going good. Great. All right. Thank you, Hothead, for all the hard work. Yeah, maybe I'll go to the game. That could be fun. I haven't been to a Clemson game in a hot minute. Maybe I'll try to get a ticket. That'd be fun. Go up to Clemson, walk around. Be the old man on campus. In the decision, the judge wrote that the court applied the familiar four-part test for injunctive relief, which mean that Ghost Adventures would have to prove likelihood of success, likelihood of irreparable harm, balance of equities, and hardship to the public interest. The judge said that Ghost Adventures failed to demonstrate a likelihood of success because Ghost Adventures must demonstrate that Miss Lizzie uses imitation of a protected mark in commerce in a way that's likely to cause confusion or cause mistake or deceive. The judge writing that the hatchet logo that Miss Lizzie's Coffee used is not similar to the mark of U.S. Ghost Adventures. So you can't get every bloody hatchet that's ever been made. The hatchet used by Miss Lizzie's is not at all the hatchet trademarked by Ghost Adventures. The former has a handle and an axe blade that features no notch. The latter is an image of a blade without a handle, but a notch halfway across the bottom of the metal folding blade. Miss Lizzie's hatchet has blood coming from it. Ghost Adventures does not. On the face, then, Miss Lizzie's hatchet is neither a trademark hatchet nor a colorable imitation. That's cute. So you both get your hatchets. The judge also noted that U.S. Ghost Adventures holds service market on just the term Lizzie Borden for hotel and restaurant services, saying Ghost Adventure does not hold a trademark on the term Lizzie. Ghost Adventures claims that Miss Lizzie cannot use a portion of the mark, at least in close proximity to Ghost Adventures' location, and especially in combination with the hatchet. The judge writing, of course, as Ghost Adventures concedes, it does not own the Lizzie Borden story or its history. Very cute. Very cute. Here, Miss Lizzie Marks associates its business with the historical story of Lizzie Borden, not the mark Lizzie Borden. The differing hatches and different colors further support the point. While Ghost Adventures has an incontestable trademark in Lizzie Borden and the hatchet, Miss Lizzie's is using neither the mark Lizzie Borden nor Ghost Adventures hatchet. U.S. Ghost Adventures claim that Miss Lizzie's coffees next doors create consumer confusion, but the judge said there was only limited evidence of such confusion, and any such confusion comes from the coffee shop being in close proximity to a historical site and not suggestive of consumer confusion arising from the infringement. I like this judge very much. This makes me happy. Indeed, the same issue would arise if Miss Lizzie called its cafe 40 Wax Coffee. They're thinking to themselves, damn, is it too late to change the name? The judge also pointed out Miss Lizzie's Coffee has posted distinct notices saying it has no affiliation with the Lizzie Borden house, which, in addition to low likelihood of confusion or infringement, further distinguishes the business. That's cute. The judge stated that while both businesses sell goods that fall within the same class of hospitality, U.S. Ghost Adventures registered the mark Lizzie Borden for hotel and restaurant services, and that Ghost Adventures and Miss Lizzie's are not actually competitors. Yeah. So, hey, 40 wax roast is not, it's not too late for the 40 wax roast. That's true. Ghost Adventures sells tours and a bed and breakfast experience. Miss Lizzie's operates a coffee shop. Different goods are sold to different classes of prospective purchasers. On the one hand, sophisticated buyers who come from afar with tickets or reservations to experience Lizzie Borden's house. And the other, buyers seeking for coffee. The absence of direct competition, the fact that parties offer different services, weakens Ghost Adventures' claims of confusion or irreparable harm. In its decision, the judge notes that U.S. Ghost Adventures contends it does not claim a monopoly on the story of Lizzie Borden, which, they can't, or its non-trademark use, which would also be hard. It merely seeks to protect the recognition and goodwill established in its registered trademark from confusingly similar uses. There is, however, no confusing similarity here. Ghost Adventures really claiming that because it registered the term Lizzie Borden along with one type of hatchet, no one can use any of these words or any hatchet symbol in a business in the hospitality field. No one can trade on the Lizzie Borden history in the hospitality field, which is a strange way to go about having hospitality. But if you want to name your business the Lizzie Coffee Restaurant, we will kill you. It's a way to go, I guess. Ghost Adventures has not demonstrated likelihood of success on the broad reach. Although the motion for the injunction was denied, they could still pursue it, but it's not going well. So it doesn't appear that things are going great over here for Lizzie Borden. So even assuming Ghost Adventures is correct in its contention, defense intentionally opened a location in immediate proximity to its business and intentionally used the word Lizzie and a hatchet in their name and signage. Given the historical significance of the location, neither of these acts alone, nor the act considered in the light of the evidentiary record, is enough. The coffee shop writing on its Facebook page, we at Miss Lizzie's just want to thank you all so much for the support. A federal judge just found our favor. We're free to keep our name. Lizzie is free once again. Lizzie Borden was acquitted. So, there's that. So, I guess Lizzie's good name continues to prosper on all these many years. So, yeah. The U.S. Ghost Adventures people, for their part, said no trial has started or concluded. We're continuing through the full process until they change their name, so as not to draw any connection. Yeah, you're not going well. It's not going well, guys. U.S. Ghost Adventures also apparently recently purchased Vasila Axe Murder House. So, you know. So they say they're continuing on, but it's not looking great for them in this case. So apparently, here's a picture of Lizzie Borden's house, I guess, or something. It's nice. It's a little. It's fine. Apparently, this is the master suite of the house. Fancy, fancy. Not sure about that wallpaper or carpeting, but apparently this is Lizzie's room, I guess, in all of its glory. And it has, of course, it has a gift shop. So that is the end of the Lizzie Borden story for the moment, man. So the coffee shop gets to keep its name and gets to continue threatening its customers with death, I guess, if they want. Drink at our coffee shop or we'll kill you. Put it right on the sign. It'll be good. All right. So here's an interesting one that came across my desk. So here we have a story of a woman's confession to her pastor being used against her in court, but the pastor is also law enforcement. Which, you can be both. There's nothing stopping you from being both. But it does raise potential problems. Thank you, by the way, for everyone who always supports the channel. Thank you for the 327 of you who are here. I'm glad you're here and having fun with me. We're having a good time. I hope you're having a good time. So let's learn a little bit more about this case of this woman's confession to her pastor, who's also law enforcement, being used against her in court, and see if we can tease out the law on this one. So, let's see if we can tease out the law. A Louisiana woman, and right away I know we're in trouble, because Louisiana's laws are foreign too. Yeah. Maybe I should sit for the Louisiana bar and see if I can pass that. That'd be interesting. Louisiana is a civil law system because France and is disconnected from the rest of the United States in ways that make law there hard. Sometimes Louisiana is weird. It is the most weird. It's more weird than California. At least California is common law, right? I'd rather sit for the California bar than the Louisiana bar. I could fake my way through the California bar. I'm not sure about Louisiana because it's here. Anyways, carrying on. The Ascension Parish, which is what they call counties down there, because they're too fancy to be called counties. They can't be called counties like anyone else because we're France, so we're parishes. Blah de da de da. The Ascension County jury found Peggy Valentine, who is 44, guilty of attempted first-degree murder and home invasion for stabbing her fiance's other girlfriend with a box cutter. Don't stab people. And when you do it, don't pull a Gus Fring. Okay? According to Valentine's attorney, David Belfield, Valentine was invited inside the house when she went there on the morning of May the 4th. May the 4th be with you, apparently. Attempting to make amends with a woman who had just had a baby with her fiance. I would think that would be the kind of thing that might make romance difficult if the other woman just gave birth to your fiance's child. I would think that would, maybe dissuade you from continuing to get married. But I guess love conquers all or something. I don't know. Anyways, there's no sign of forced entry, no doors broken, no windows broken. Someone had to open the door. He argues Valentine was led inside the house before the woman got into a fight, leading to the stabbing. Okay. However, the prosecutor said that Valentine broke into the house and attacked the woman while she was sleeping. After the woman was taken to the hospital and treated for injuries. All right, so, okay. Valentine reportedly called her pastor, who happens to work for the Ascension Parish Sheriff's Office. He advised her to talk to investigators. Her attorney said she voluntarily went to speak to investigators because she believed she only defended herself. Dude, don't talk to the police, like, ever. If your pastor tells you talk to the police, don't talk to the police. Just don't talk to the police. That's a bad move. It was obvious that they interrogated Peggy for a moment. You think? She was very, very distraught at the time. She stopped talking to him, shut down, and demanded to speak to her pastor. Valentine then confessed to her pastor, but another deputy was still present in the room. Well, that's the end of that. The presence of the third party shatters the privilege. So, yeah. So she confessed to her pastor, but another deputy was still present in the room. She admitted to going to the house and trying to connect her fiancé with a woman. Her attorney tried to have the confession removed from evidence, arguing pastor privilege. The attorney said the pastor never clarified to Valentine that what she said could be used against her. Are you working as a pastor or deputy? He never once told her, Peggy, you have to be careful what you say in there because I'm working as a police officer. What you can will be used against you. He doesn't have to. If she went there voluntarily, they don't even have to Mirandize her because she's not under arrest. So, yeah. The attorney explained there are 3 prongs of the pastor protection clause. First, the pastor must be a member of the clergy. Second, the conversation must be one where the person is seeking guidance. And third, the conversation must be confidential, which is where this thing is blowing up. However, the state argued the conversation wasn't confidential since there's another deputy in the room, which is exactly correct. The presence of the third party shatters the privilege. Because even if you can't get the pastor to testify about it, you know who else can testify about it? The other person standing in the room. Because they were there. So, yeah, third party shatters the privilege. The judge agreed with the state and ruled there's no expectation of privacy since Valentine wasn't alone. The judge allowed the jury to hear the confession multiple times. If you can't trust your pastor, who can you trust? Well, not in this situation. So, yeah, that's the law. That's the law. So that's, the presence of the third party shatters the privilege. Therefore, there's no privilege. Therefore, yeah. So, Maybe next time, don't go to a pastor who's also a cop, I guess. And if you want to confess to your priest, do it in private. So that's that. All right. Florida man coming to the rescue to make things fun and interesting for everybody. A man has been ticketed for impersonating law enforcement. But this isn't your typical case. This is a special one. And the police, I think, are on the wrong end of this one. So let's learn about the police ticketing this guy for impersonating law enforcement. Florida cops have been mocked for ticketing a man driving a booty patrol truck that they say looks too close to a border patrol truck. See, border patrol, booty patrol. Yeah. So, it's going just that well, man. It's going just that well. The Florida cops don't know how to take a joke. That's what's going on. They don't know how to take a joke. The Florida Sheriff's Office is being mocked online after deputy ticketed a driver for impersonating a law enforcement over his humorous booty patrol truck that they say resembles a border patrol vehicle. The deputy with the DeSoto County Sheriff's Office pulled over the white Chevy Silverado pickup truck and issued the driver a $113 citation along with citation for adding red and blue lights to his ride. The truck features a green diagonal stripe, an official-looking federal emblem, and red and blue flashing lights on its dashboard, making it easy to mistake for a U.S. Border Patrol vehicle, if not for the words Booty Patrol, written in large capital letters, and National Booty Behavior Protection plastered on its side. The Sheriff's Office accuses the man of impersonating law enforcement and posting several images of the vehicle on Facebook to raise awareness among community members. And then asked anyone who's been pulled over by a suspicious vehicle to reach out to the office and add that residents' cooperation is crucial to ensuring the safety of the community. The man, for his part, chose to add Booty Patrol to his truck because it's the closest you could get to Border Patrol and still have a B in it. It was just to have a little fun, he said. It was never my intention to pull people over. The Florida teen says he's never pulled over anyone, nor does he have plans to. He also says that most cops get the play on words, but the DeSoto County pulled him over was not one of those officers. Pictured here is the Booty Patrol truck, which says Booty Patrol right on it. So, yeah. Yeah. The deputy slapped him with a fine of $113 for displaying red and blue lights on his rim in violation of Florida law. But he claims he never turned on the lights while driving and only uses them when parked and on private property. Here again is a picture of the Booty Patrol car, which, pretty good, I have to say. It's pretty good. Another commentator said the truck is just a show car, and the sheriff's crackdown left him saddened. It's a little sad to see this happening in our community, he wrote. This is merely a show truck, always has been. Never seen him with blue lights on, and he does this all over DeSoto, Manatee, and Sarasota County. Yeah. Apparently, another man, a Californian, hacked his Ford F-150 Raptor to look similar to a Border Patrol vehicle, but instead opted for Thought Patrol as his fake agency of choice. So, not the only person. I didn't know these were options in my life. I'm thinking about having my car repainted in Border Patrol colors, and then we can decide what a good alternative to Booty Patrol and Thought Patrol is. We can have some ideas. What are some good alternatives so that we can continue on the theme? Yeah. Oh man, this is good stuff. Bee Fish Patrol. I don't think that's going to really work. No one's going to get the joke, but I appreciate you trying. Bee Fish Patrol. That would work for you and me and no one else. Where am I streaming from? I'm streaming from my parents' home because I love them. Visiting the folks. Yeah. Wifey Patrol? Wifey Patrol's not good, bad. All right, so let's deal with Yale being stupid. Yale issued a correction and then issued a retraction to the correction. This is one of the stupider stories I've seen over the Israel thing. I continue to be amazed, personally, with the pro-Palestinian and even pro-Hamas and even pro-wiping out Israel commentary that's out there. It's mind-blowing to me. I don't understand it. I don't understand these people who apparently are. I don't understand these people who are tearing down signs of missing children on campus. I don't understand these people, some of whom have actually come out as pro-Hamas. I don't understand these people who are openly calling for the eradication of the Jewish state and possibly Jewish people. It is very, very strange to me. The whole thing is really weird. I don't get it. But Yale University did a stupid. Yale University does stupid. So Yale, like many campuses, has a student newspaper. So Yale student newspaper, there was a column written in which the person who wrote the column wrote that Hamas raped women. Then Yale Daily News posted editor notes saying the claims were unsubstantiated, and then had to retract the correction. Because of course they did that. Of course they did that. Yeah. Yeah, I saw London police were even ripping down posters of kidnapped people. I saw that. I don't get it. I don't understand. I don't understand it. I don't get it. I don't get it in particular from what seems like particularly left-leaning groups that if the Palestinians were in control would kill them immediately. Like the ones that really get my attention are like Israelis for Palestine or gays for Palestine. It's like, dude, I don't know if you've noticed or not, but apparently you haven't for some reason. But the Palestinian Authority would kill you both, like right away. they would throw you off the roof of a building. It's like it's the weirdest thing. It's the weirdest thing. It's like, do you know anything about these people? Do you know anything about how they treat gays or Jews okay. I don't, it seems incredibly odd. I mean, on a purely selfish level, right? Like, I don't understand it from first principles because I think Hamas is evil, but purely on self-preservation grounds, you think that you would not support them. Anyways, so Yale Daily News had a columnist who wrote Hamas raped women. Yale Daily News editors then posted a note saying the claims were unsubstantiated and then had to retract the note. The October 12th column by Yale student Cesar Tariq, titled Israelis for Palestine a Hate Group, was hit with an editor note reading, "This column has been edited to remove unsubstantiated claims that Hamas raped women and beheaded men," which they did that. There are the GoPros of them doing that. Yeah. Another column published on October 13th said, "Stop justifying terrorism," similarly accused terror group of raping women during the October attack on Israel, and also had the editor note attached. The newspaper then writing, "The news was wrong to publish the corrections." By the time of the first correction, there had been widely reported coverage from outlets such as Reuters publicly verifying that Hamas raped and beheaded Israelis. Because of course they did. Because of course they did. There have been multiple reports that Hamas terrorists committed rape during the rampage. Israel released footage. Incidentally, they've been releasing footage from Hamas, from their own body cameras, that show this, and then like putting a baby in the oven and then setting the oven on to let the baby bake in the oven, because apparently that's how we have fun over there if you're Hamas or something. So dumb.